Good morning to everybody joining us from the West Coast, and good afternoon to everybody joining us from the East Coast today on this continuing education webinar on revenue protection and how your dental office lease agreement can protect your production. Should be a very educational and informative continuing education webinar this morning or this afternoon for those of you on the East Coast. For those of you who I haven't had the privilege of introducing myself to, my name is Brendan Madden. I'm a senior consultant and lecturer with Serous Consulting Group. I most recently took over the management of our Canadian operations, which means that on a daily basis, I strategize, I consult, and I advise doctors all across the country in different situations, right? Doctors looking to start a practice or open a new location, doctors looking to renew their lease agreement, doctors looking to relocate a practice, renovate a practice, doctors looking to expand or remodel, and very importantly, those doctors looking to transition and ensure that their lease agreement is well structured to support that endeavor and their endeavors no matter what stage of career that they're in. I really appreciate everybody taking the time to join us this morning or this afternoon. In speaking with some of you prior to the course commencing today, it sounds like a few of you have specific questions about a certain situation that you are experiencing or have experienced. And some of you just have the inclination and the willingness to learn a little bit more about commercial real estate and the lease agreement as it relates to the business of dentistry and the dental practice, respectively. So I certainly want to ensure that I address all of your questions today through the course content. And following the course today, if any of you have questions that were not addressed, I'm certainly happy to, either via email or over the phone, address those questions in any way that I can. I will, time permitting, have a little bit of a question and answer period following the course today. So again, if you have any more individual personal questions that you would prefer to ask individually or one-on-one, save those for after the webinar, and happy to address those with you individually. For those of you who may not be as familiar with who Serous Consulting Group is and what it is that we do, we are a healthcare and dental specialized tenant representation firm. We were built for dentists, by dentists, back in 1994, and we represent healthcare professionals in commercial real estate matters, but primarily the negotiation of dental-specific lease agreements, dental office lease agreements. We're very unique. Serous is the only firm in North America that does exactly what it is that we do, whereby we in-house have a legal team comprised of real estate attorneys, all who have backgrounds in healthcare and tenant representation. And we also in-house have a leasing team comprised of former commercial real estate brokers and analysts. And that's the team that's able to provide us with market research across the country in terms of property availabilities, landlord research, demographic reports, rental rate reports, things of this nature and metrics of this nature. And finally, we have our in-house consulting team, of which I'm one of our senior consultants, we all have backgrounds in economics, sales, marketing, and finance, as well as business, and on a daily basis, our consulting team strategizes, consults, and advises doctors all across North America, no matter what situation they're in, whether they're looking to start a practice, renew a lease agreement, and ensure the legal and economic terms are well structured, relocate a practice, renovate a practice, expand or remodel a practice, and very importantly, those doctors looking to transition and ensure that their lease agreements are well structured to support that endeavor. To date, we have negotiated well over 10,000 healthcare specific lease agreements, and on an annual basis, we represent over 1,000 doctors across North America in the negotiation of their dental and healthcare specific lease agreements. We have the privilege on an annual basis of providing over 100 continuing education courses to doctors all across the country, be it a seminar, a webinar, a lecture, or a study club. We have the privilege of providing hundreds of continuing education credits to doctors across the country on an annual basis. We also lecture and have the privilege of lecturing at some of the larger dental conventions that many of you would be familiar with on an annual basis, such as the Greater New York Dental Meeting, the Pacific Dental Conference, the Yankee Dental Conference, the California Dental Association, the Ontario Dental Association's annual spring meeting, and of course we have the privilege of working with doctors nationwide. I had our leasing team draw up this illustration that you'll see in front of you of some of the clients that we've worked with most recently across the country. And I had our leasing team draw this illustration up for a couple of different reasons. First and foremost, as you watch through the animation, you may recognize some of your colleagues or doctors you've worked with in the past on this illustration. Secondly, it goes to show the experience that Serous and my teams internally have had in negotiating healthcare-specific lease agreements all across the country, in dealing with both institutional and non-institutional, smaller mom-and-pop landlords, if you will. But this illustration also shows you that the issues and the red flags that we identify in healthcare lease agreements, they don't only exist in certain parts of the country or in certain states or in certain provinces, right? It's not only in San Francisco, it's not only in Manhattan that some of the healthcare red flags or healthcare issues in lease agreements arise. If you're leasing space and you are a healthcare professional, there is a significant possibility that the issues we will be discussing are inherent in your lease agreement and should be dealt with accordingly moving forward, no matter where you are in the country. I thought it would be beneficial, before jumping into the core content for today, to provide you all with a little bit of a snapshot into markets across the country and a little bit of an update on the vacancy rate and the rental rate that are trending across the country. I thought it would be beneficial to start in Boston, and as you can see per the illustration in front of you, vacancy rates, which are shown on the left axis, are trending downward. Since the beginning of 2013, vacancy rates in the Boston market have been slowly but surely decreasing. And as you can see on the left-hand axis, vacancy rates are trending at approximately 6.5%, which means that about 6.5% of the inventory in terms of spaces available to lease, commercial real estate, is available for doctors and tenants to lease. As you can see on the right axis, the rental rates, as vacancy rates have been decreasing, have been trending upwards. In economics, when supply or when inventory decreases, prices tend to increase. And this is exactly what you're seeing in the market. And this is happening in most markets across the country. But as you'll see, in Boston, rental rates all in on an annual basis are trending at approximately $44 per square foot. And as mentioned, vacancy rates are trending near 6.5%. Next up is Chicago. Very similar trend in terms of both vacancy rates and rental rates. And as I mentioned, this is the trend that is happening in most parts of the entire country. Right? As you can see, from 2013 until today, vacancy rates in Chicago have been decreasing fairly significantly, from 16 down to about 10.5% today. And rental rates have been increasing since the beginning of 2013 for commercial spaces. As you can see, in 2013, rental rates were trending at about $16.50 per square foot on an annual basis, all in. And today, on an all-in basis, rental rates in the Chicago market are trending toward $19.50 per square foot on an annual basis. That's about $3 per square foot higher than what we saw rental rates at the beginning of 2013. A similar picture in Orlando, Florida. Vacancy rates since early 2013 have been slowly decreasing with jumps here and there in the opposite direction. And as you can see, the beginning 2 quarters of this year, vacancy rates have been increasing. They went from, at the end of 2017, approximately 4%, to, after Q2 of 2018, or the second quarter of 2018, close to 7%. So there was a large amount of inventory that came on the market in Orlando that represents this difference and uptick in vacancy rate. But as you can see, in most pictures that we've painted so far, and similar to other markets, rental rates over the same time period from 2013 to quarter 2, or the second quarter of this year, have been slowly trending upwards and are hovering at about $23 or $23.50 per square foot on an annual basis. And finally, in San Francisco, California, we see a very similar story. Vacancy rates are trending just above 1% today. So vacancy rates since the beginning of 2013 have decreased significantly, which means there is very little inventory of commercial real estate or commercial space for lease in the San Francisco market. Accordingly, rental rates have increased quite significantly, from about $25, if not $24.50 per square foot on an annual basis, to above $31 per square foot on an annual basis in terms of rent. what does this mean for those of you in similar markets or in markets across the country? Well, what it really means is we need to be proactive. We need to begin to lock in rental rates sooner rather than later. Why wait for the market and rental rates to continue to increase when, if we have the ability, we can renegotiate our rental rates and the legal terms and provisions in the lease agreement soon, thereby locking in the lower rental rates that we would experience sooner rather than later, and therefore providing with more cash flow available to invest into the practice and those production increasing investments. So what is the purpose of today's webinar? Well, it's fourfold. I want to take a look at some of the clauses within each and every one of your lease agreements that can be used to protect or increase your production. The first of those clauses is the use provision, which will be included in all of your lease agreements and outlines what it is exactly that you can and cannot do within your space in terms of the services that you're offering. And I would like to go through some examples of how you can maximize the use of your space to afford yourself the ability to expand your service offerings in the future if you choose to do so. Along the same lines, I would like to explore the exclusivity provision and exclusivity protection within your lease agreement. Following the exclusivity provision, I would like to discuss an article that many of you may be familiar with and some of you may not be familiar with. This is the relocation article, which is in a lot of doctors' lease agreements, in a lot of healthcare lease agreements across the country, and which can prove to be detrimental to the practice if not handled appropriately. The Relocation Clause is an article within a lease agreement that grants the landlord the ability to relocate you within the building to any other unit, including basement units, upon a certain time period's notice, typically 30, 60, or 90 days. Ask yourselves, for those of you joining us today, what would happen and what would I do if tomorrow the landlord came into the practice and told me I needed to relocate within the building in 30 days? And finally, I'd like to discuss the death and disability provision that we look to include in every one of our clients' lease agreements. This is a very important article to me. I think it should be included in every doctor's lease agreement in the world as standard language, but unfortunately that is not the case, and I need you all to leave here and leave the course today with a thorough understanding of what is a death and disability provision, how can I use it to protect myself and the practice, but most importantly, how can I use it to protect my family in the event of an unforeseen problem or circumstance arising with the lease agreement and ultimately with the practice. So what is a lease agreement? When I ask this question in front of an audience at my live seminars, I'll typically get a few standard answers. The lease agreement is a contract. The lease agreement is an agreement. I've even heard that the lease agreement is a marriage between landlord and tenant for the entirety of the term that you decide to sign. I encourage each of you to ask yourself, what is a lease agreement? And think of the very first word or the very first thought that comes to mind when I ask you, what is a lease? In my experience, And in presenting this concept to rooms of doctors across the country, most of you will be thinking about rent. In many cases, the very first thing that comes to your mind when you think about a lease agreement is rent. It is the occupancy expense that I owe to the landlord on a monthly and annual basis. And while that's true, and while an agreement, a contract, all of these answers are true, and in theory we know this intuitively, I would argue that the lease agreement is actually one of these. Not only is the lease agreement a check, I would argue that the lease agreement is one of, if not the most expensive checks that you will ever sign or have signed in your entire lives, both professionally and personally. Right? Why is it that when we think about a lease agreement, the first thing that comes to mind is rent? Well, from my perspective, it makes sense for each of you that when we think about a lease, we think about rent and the occupancy expense, because for most of you, it's one of the largest items on your income statement. It's one of the largest expenses for the practice on a monthly and annual basis. Apart from staff salaries, apart from sundries, typically the occupancy expenses and the rent that you pay to the landlord on a monthly and annual basis is one of the largest expenses for the practice. So it makes sense that we're thinking about rent. However, I would again argue for each and every one of you that the lease agreement is not all about rent. The lease is one of, if not the largest check that you have ever signed and that you will ever sign in your entire lives, both professionally and personally. Now, what do I mean by this? On average, we see rental rates on average across the country all in at about $30 per square foot. On average, in my experience, most doctors will lease approximately 1,500 square feet for their first and subsequent offices. In some cases it's greater, in some cases it's smaller, but on average about 1,500 square feet. Well, if we're paying $30 per square foot and leasing 1,500 square feet, we're paying $45,000 to the landlord on an annual basis for the rental obligations, for our occupancy expenses. Over the initial 10-year term that the majority of dentists sign when they sign their first lease agreement, that $45,000 becomes $450,000 that we have signed on to pay the landlord over the course of that initial 10-year term. I hope we can all agree that on average, doctors and dentists will spend approximately 30 years in private practice. So that $450,000 over the first 10 years becomes $900,000 over the first 20 years of that lease agreement, which becomes $1.35 million over the 30-year term that most of you will spend in private practice. Now, is there anyone on today's continuing education webinar who has rent that decreases on an annual basis? Unfortunately, that typically is not the case. So for this example, we have assumed that rent will stay flat for the entirety of your career and for the entirety of the tenancy that you occupy the premises. I hope that if someone would have put the lease agreement in this perspective as the largest check that you have ever signed or likely will ever sign, you may have spent a little bit more time going through the 40, the 50, the 60, the 100 pages that follow the first 2 pages on the lease that discusses the rent and the term. It's one of my goals by the end of this program that all of you leave here today knowing that the lease agreement is not all about rent. Rent is important. We pay, and one of the most significant expenses for the practice is our occupancy expenses. So it's important that we're paying fair and affordable rental rates. However, the legal terms and provisions need to be well structured and dental specific. And in my experience, the legal terms and provisions within your lease agreement can either increase practice value by hundreds of thousands of dollars or can act as a $100,000 plus liability for the practice over the course of your tenancy. So why is the office lease agreement so important then? Well, first and foremost, the lease agreement and the location of the practice is the foundation. Without a location, we cannot see patients. If we cannot see patients, we cannot produce dentistry. And if we cannot produce dentistry, we cannot earn a living. Without a well-structured dental-specific lease agreement in place between your location and the practice, your certainty in your location is not guaranteed, period. Secondly, the business of dentistry is one of, if not the most expensive businesses to enter into in North America. On average, in my experience, doctors and dentists pay about $150 to $200 per square foot to build out a dental practice, and that does not include equipment. And unfortunately, in my experience recently, that $150 to $200 per square foot is getting closer and closer to $300 to $400 per square foot in certain areas of the country in order to build out a dental office. And again, that does not include equipment. So if we're looking at about $200 per square foot to build out a 2,000 square foot office space, we're looking at about $400,000 of investment just to build out the space, not including equipment, right? That just includes the plumbing, the electrical, the demising walls. If we take equipment into account, most of you are looking at $750,000 to $1 million just to have the practice ready to start seeing patients. And it's for this reason that each and every one of you should have a better lease agreement in place than any of your neighbors and any other retail establishment in the country. Along the same lines, once we have built our dental practice, it's very difficult, very time-consuming, and very costly to then have to relocate that dental practice. In my experience, there will be no one on the webinar this afternoon who purchased their practice apart from a tuck-in acquisition with the intention to relocate it in a couple of years. Most doctors, when they start their practice or purchase their first practice, have the intention of keeping it there for a long period of time. Again, typically at least 30 years. So for that reason, and the investment and the time it takes to relocate a dental practice, it's critical there are no unforeseen areas in the lease agreement that could cause us to relocate unexpectedly. We need to ensure there are no landlord termination rights built into the lease agreement that could have you kicked out of the space upon 30 days notice. And finally, the lease is so important because it has a significant impact on your ability to sell the practice. For those of you who are not familiar, when we look to sell a dental practice, what typically occurs is we will transfer the lease agreement from the selling doctor to the purchasing doctor, or assign the lease agreement from the seller to the buyer. And for this reason, the lease agreement has a significant impact on the sale of a dental practice, and I would like to explore that a little bit more thoroughly. So what are the three key sellable components of a dental practice? Ask yourself, do I know what are the three key components that go into the value that I'll ultimately attract for the sale of my dental practice? Number one is equipment, right? What is the appraised value of our equipment? What is the equipment worth to the doctor who is looking to buy our practice? Number two, the second key component that goes into the sale of a dental practice is the goodwill. There's a lot that goes into goodwill, and I have yet to hear any one standard definition for goodwill, but from my perspective, goodwill includes the intangibles for the practice, the patient base that we've developed, our reputation. Anything intangible that does not have a value immediately attributed to it is included in goodwill when we look to sell the practice, and it contributes a significant amount toward the sale of our dental practice. And finally, the third key component of the dental practice sale is the lease agreement. For those of you who are unaware and have not been through the assignment or assumption of a lease agreement, the lease can contribute up to 100% of your practice value when you look to sell your practice. Again, when you look to sell a dental practice, the lease agreement can determine up to 100% of the practice sale value, that value that you receive for the sale of your practice. The lease can make or break the sale of a dental practice if it's not properly structured, and each and every one of you should take some time to go through the assignment and subletting article in your lease agreement to ensure that it is well structured, and if it's not, take action proactively to amend the assignment and subletting article and ensure that you can sell your practice and transfer the lease agreement with zero interference from the landlord, period. So what should your lease agreements do for you? Well, first and foremost, they should absolutely provide for fair and affordable financial terms, right? We've discussed occupancy expenses are one of the largest expenses for the dental practice on a monthly and annual basis. And so it's important to ensure that we're paying fair and affordable base rental rates. But the base rental rate is not the only item that goes into an economic negotiation when it relates to a lease agreement for a dental practice. For those of you looking to start or purchase a dental practice, are we obtaining a tenant improvement allowance from the landlord, which would be $1 per square foot contribution the landlord is willing to provide in order to assist us in building out or constructing that dental practice? Are we looking to obtain free rent period? Are we looking to obtain fixturing period? Are we signing a triple net lease agreement, or are we signing a gross lease agreement? For those of you who are unaware the difference between the two, most of you will be operating under a triple net lease agreement. And what that means is you pay a base rental rate, which is $1 per square foot. But on top of that base rental rate, you pay your proportionate share of the taxes, the maintenance, and the insurance costs that are levied on the building. The taxes, the maintenance, and the insurance are the three nets that make up a triple net lease agreement. For those of you looking to renew a lease agreement, are you certain that the maintenance costs which are being passed through to you are fair and reasonable? Are you receiving detailed and itemized statements on an annual basis showing an exact breakdown of what went into the operating expenses or the additional rent charges that the landlord is passing through to you? Or are you receiving solely a summary reconciliation statement which does not provide much detail at all on an annual basis? And in the event you determine the costs the landlord is passing through to you may be unreasonable, do you even have any recourse built into the lease agreement to do something about it? These are all items that need to be taken into account in an economic negotiation of a lease agreement, and we cannot get stuck on and give up all of our leverage trying to negotiate the base rent. A $1 per square foot base rental rate reduction for the majority of you would save you about $1,500 or $2,000 on an annual basis. In my experience, the majority of you will bill that in about 3 to 4 hours. So we need to stop giving up all of our leverage in negotiations on trying as hard as we can to get $1 or $2 base rental rate reduction, and ensure that we're taking into account every aspect of the economic negotiation as well as the legal negotiation. The lease agreement should provide all of you with long-term stability and security in your spaces. For most of you, that means a 10-year term with 2 or 3 5-year options to renew the lease agreement, which are transferable to a buyer of the practice. The lease should minimize any risk and exposure that we have under the lease agreement and in our businesses. In my experience, most of you who are listening in today will have provided unconditional, irrevocable, absolute, and continuing personal guarantees, and in some cases you've also provided a spousal guarantee. Depending on where you are in your career, that is absolutely unreasonable. When you're starting your first practice, I'm not so concerned about providing some form of a limited personal guarantee, but they should not be absolute, irrevocable, unconditional, and continuing personal guarantees. They should be limited. For those of you at the latter stages of your career, you should be looking to remove any type of personal or spousal guarantee that has been provided under the lease agreement. At this point, you've shown your ability to pay the rental rate. You've shown your ability to successfully operate your business. Much less reasonable for you to be on the lease agreement personally, and certainly unreasonable for your spouse to have provided a personal guarantee. The lease should maximize your flexibility. What happens if you hit capacity in the space and you need to expand? Do you have that ability built into the lease agreement in the form of a right of first refusal? Do you have exclusivity protection over general dentistry and all subspecialties of dentistry? Or can the landlord move in an orthodontist or an oral surgeon. In the event, God forbid, something were to happen to you and you were no longer able to practice wet finger dentistry, or you were to pass away, do you have recourse built into the lease that would allow you to terminate the lease, or your estate to do the same, or you to sell the practice, or your estate to do the same? These are all items that increase your flexibility that we include in all of our client lease agreements. If we're able to amend your lease agreement to ensure that all of these items are addressed and taken into consideration, the lease agreement will eventually act as an asset and increase your practice value when you look to sell, as opposed to act as a liability and potentially a detriment to your ability to sell the practice. There are a few clauses in the lease agreement that you can utilize to protect your production. I'd like to go through a few of those articles now. So if you have your lease agreements with you, it would be beneficial to follow along to ensure that you have these articles, and if you don't, ensure that you know where and how to include them in the lease agreement. The first and foremost is the permitted use clause. Unfortunately, in my experience, the majority of your permitted use clauses will state that you can operate a dental clinic in the space, period. The permitted use clause outlines in your lease agreement what it is that you can and cannot do in the space in terms of the services that you're offering. And it's important that this permitted use clause is broad enough to allow you to provide all subspecialties that you look to provide, as well as ancillary services such as Botox, Juvederm, or spa-like services, which are becoming more popular in certain practices across the country. So instead of the permitted use provision saying you can operate a dental clinic, it should say you can operate a professional general dental practice, including but not limited to all oral health and wellness activities ancillary thereto. That way, it's not only basic bread and butter crown and bridge work that you're able to perform in the space without being in default of the lease. You can do all subspecialties that are included under general dentistry and any ancillary services. Very important for all of you who are offering anything apart from bread and butter crown and bridge work that you have a broad permitted use provision that encompasses all subspecialties of dentistry and does not just say a dental clinic or dental practice. And for those of you who are saying, well, dental practice and dental clinic includes all subspecialties of dentistry in commercial real estate and in lease agreements, that is not the case, and we need to ensure that permitted use article is broadened. Along those same lines, we should look to obtain an exclusivity clause in our lease agreement. What an exclusivity provision would state is that for the life of your lease agreement and any options to renew, the landlord could not move in another general dentist or specialist into the building. This is extremely important for most of you who are general dentists and specialists. For those of you who, for example, are general dentists, but you're providing orthodontics, Invisalign, or oral surgery, for example, it's important that we have exclusivity protection in the lease agreement over general dentistry, but also over all subspecialties of dentistry. Certainly, those subspecialties you seek a lot of production from. I worked with a doctor about a year ago who was in a medical building She was a general dentist, and she obtained about 20% of her production from Invisalign and orthodontic work. One day, the landlord decided to move an orthodontist into this medical building without consulting the general dentist, who had exclusivity over general dentistry. The orthodontist obtained exclusivity over orthodontics, and the next day, this doctor, the general dentist, received a cease and desist notice stating that moving forward, she could no longer provide any type of orthodontic work, including Invisalign, in the building, and she lost over 20% of her production overnight. So for those of you who see a lot of your production coming from subspecialty work, oral surgery, endo, perio, ortho, very important that we don't just have exclusivity over general, we have it over general and all subspecialties. The death and disability provision. It's basically a free life and disability insurance policy that we bake into all of our clients' lease agreements. What the death and disability provision allows for is, God forbid, something were to happen to any one of you and you were unable to continue practicing wet finger dentistry. You would have the right to terminate the lease or sell the practice. And God forbid you were to pass away, your estate would have that same right to terminate the lease or sell the practice. Imagine, for those of you in a space where rent is fairly significant, what happens if you can no longer practice? Is there recourse built into the lease that would give you the right to terminate it or sell the practice? And what happens for those of you who pass away? Does your estate have the ability to terminate the lease, or will they be left paying rent for the remainder of the lease agreement? Do they have the ability to sell the practice in that event? It's critical that the death and disability provision is included in each and every one of your lease agreements, because we never know what might happen. And given the physical nature of what it is that all of you do on a daily basis, you know, it happens. Carpal tunnel, hand tremors, back issues, and we need to protect against it. The relocation clause. What a relocation provision in a lease agreement states is, upon a certain time period notice, typically 30 days notice, the landlord can approach you and tell you to relocate within the building. What this means is the landlord could have you, upon 30 days written notice, relocate from your current unit to another unit in the building. This is not ideal and can be detrimental for dental practices. At the very least, you will likely see some attrition and some downtime in the business. And in some cases, you will be relocated to a suite with no natural light, less visibility, less or more square footage and rent that reflects that. You might lose an offertory, for example, and you may be left with the bill to pay for the entire build-out and relocation of your dental office. This clause is not a good clause to have in a dental-specific lease agreement, and the ideal position would be to completely remove it. If the relocation clause cannot be completely removed from your lease agreement, that notice period needs to be extended as far as possible. It should be upon a minimum of 365 days written notice, and there should be language in this article that explains exactly that the landlord will pay for the entire relocation and construction of the new space, and it should outline how and when they will reimburse you and pay for those costs. You'll see on the illustration in front of you a number of other significant articles that can be trapped in your office lease agreement. All of these articles need to be dental specific, and they need to be carefully reviewed for any potential red flags or any potential problems that are inherent in these clauses. The demolition, the relocation articles, the financial statements articles, the restoration, personal guarantee articles, these are all critical items that, if not addressed, can cause serious issues for the practice and your goals, both in the short and long term. And I would encourage you to ensure that every one of these articles in your lease agreement are carefully reviewed, and there's action taken proactively to amend these articles to ensure that they're dental specific and will add value when you look to sell the practice, right? All other things being equal, if we can amend our lease agreement to ensure that they are dental specific, well structured, and have the flexibilities that we've discussed today built in, most buyers will pay a premium for your practice rather or relative to the practice across the street. Protect your practice and production for a long-term and profitable practice by properly structuring your lease. You don't get what you deserve in negotiation. You get what you negotiate in your lease agreement, right? We do not get what it is that we don't ask for. And it's important that all of you recognize your position as a coveted tenant by most landlords across the country and utilize that position as leverage to ensure that we're asking for dental specific language in our lease agreement. So if I decide or if I find that my lease agreement has some red flags and some problem areas that need to be addressed, when is the best time? When should I enter into these negotiations and conversations with the landlord? The best possible time to begin negotiations with your landlord is anywhere from 36 to 24 months prior to a lease expiration or an option to renew deadline. For those of you who have options to renew your lease agreement, it's critical that you look at the option to renew deadline as your lease expiration date. I've worked with too many doctors who have missed that deadline, and if that happens, the landlord really can put whatever they want in front of you in terms of a lease agreement, and you're forced to sign it unless you want to relocate the practice, which at that point in time is very difficult, if not impossible to do in such a short time period. So again, the best time to renegotiate terms of a lease agreement, both economic and legal with a landlord, is 36 to 24 months or 3 to 2 years prior to a lease expiration date or option to renew deadline. When we get past the 2-year mark, time starts ticking. Once we hit a year and a half prior to expiration or lease renewal deadline, the landlord knows it's becoming more and more difficult for you to relocate the dental practice smoothly and without stress or downtime, and they use this as leverage. Landlords will try to get you as close as possible to your lease expiration date or your option to renew deadline to enter into negotiations, and it's important that we increase our leverage by starting the process early, 2 years before an expiration date. At that point in time, the landlord knows if we need to relocate because negotiations don't go well, we have that ability and we will be able to do so. That thereby increases significantly your leverage in negotiation. One of the services that we offer at Serous is something that we call a critical date and risk analysis. It is a $1,495 service, which entails a 3 to 4 hour review of your lease agreement by our legal and consulting team, and a scheduled phone call, typically about an hour, to go through your short and long-term goals for the practice and your ideal vision, your ideal outcome from negotiations and the practice in the long term. And finally, a discussion of some of those red flags or problem areas in your lease agreement and a strategy, a tactical strategy that you can utilize in order to effectively negotiate and amend those problem areas. And for those of you on the webinar today, I'm happy to announce that we are providing complimentary critical date and risk analysis to each and every one of you. So a complimentary lease review consultation for any of you who would like a careful and complimentary review of your lease agreement to look at ways you may be able to enhance the lease and enhance the value of the practice when you look to sell. We're happy to offer these to each one of you on the course today. My contact information is on the illustration in front of you, and for those of you who would like a complimentary review of your lease agreement, you can call or email me, and I would be happy to coordinate the review of your lease agreement and the 1 hour consultation where we strategize, go through the issues that we have found in the lease agreement that need to be addressed, as well as a game plan and tactics that you can utilize in order to address those issues and red flags. So I want to take this time to thank you all very much for joining us over the past hour. I hope that all of you found it beneficial. For those of you who have questions that I was not able to address over the past hour, feel free to call or email me. I'm happy to provide guidance, provide advice in any way that I can. And for those of you who, again, would like the complimentary lease review consultation, feel free to call or to email me once the course is over, and we can coordinate a good time for your complimentary review. Thank you all so much. Have a wonderful afternoon and a wonderful morning for those of you on the West Coast. And again, if there are any further questions after the program, please don't hesitate to contact us.